What do you do if your wife wants to back out of the divorce that she filed, but you want it to continue? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan. And today we're going to continue our video series, which is designed to educate and inform the public. So please subscribe to our channel. Well, it is true, and we've had cases like this before, where we will file a divorce and one of the parties doesn't want to continue it, and what happens? This is the reason why, because technically if you're the plaintiff and you file for divorce, midway through you decide you want to file a dismissal, you can dismiss your case. You can file a motion if the other side won't agree to voluntarily dismiss your case. You can not take action, and the court might dismiss your case as a function of non-progress. Therefore, what often happens in these cases, and it's not all the time, but it's generally the practice here at our firm, when we are served with a complaint, we file a counter complaint for divorce. Why? Even if we allege the same things, even if we say there's been a breakdown of the marriage and we're filing our own, you might think, well, what do you got to do that for? Why, spend the resources, file a counter complaint and allege the same thing? What's the point? The point is very clear. The point is now the case isn't dependent on the plaintiff's filing. Now it's as dependent on your filing as theirs. So if they bail out, that's fine for them, but you're still going forward. That prevents you, or put it this way, it causes you to not have to refile the case later on or file a motion to file a counterclaim later on, and ultimately could save you money in a situation where the other side decides they're better off staying together. Why? Probably financially. Maybe they're better supported, because a lot of times what we see is somebody will start this case and realize, gee, when it ends, we're going to have to sell the house. I'm not going to have this support. I'm not going to have that payment. I'm not going to have this. I'm not going to have that. So they file this. Meanwhile, during the case, all the bills are still being paid. And then when it comes to the end, they change their mind. Add another year to the case. They get another year of support. If that happens and the other side wants to combat that, rather than having to file motions or objections to a dismissal, rather than having to do that, if the other side had a counter complaint in place, it might not be necessary to do that. That's why lawyers do that. But the answer is, even if the other side wants to bail on it, you do have options. You have an option to file a motion to file a delayed counter complaint. You have a motion an option to object to the dismissal and then ask the court leave to file your own pleadings. There are these options, but it's always a good practice, if you think that may be a possibility, to have a counterclaim filed on your behalf so you're not subject to that later on down the road. If you have any questions about your particular case, reach out. We'll be glad to help you out.